Hi, I'm John Leonard. I'm a corporate lawyer in Denver, Colorado with Fairfield and Woods. We have a series of videos on our website that you'll find interesting, entertaining. They deal with aspects of your personal life and how the law affects it, as well as your business life. There's videos on how to start a business, how to run it, eventually sell it. Today, we're talking with Adrian Castro. Adrian does employment law and commercial litigation. Adrian has an article. We're just going to jump through the names of some of these statutes. It's been really active in Colorado, the number of statutes that have been enacted in the last couple of years. So can we just jump through the names of these statutes and you say a few words about it? People that want to call you for more information or actually read what you've written, it's on our website, but you've done an article called Changing Times Creates a Minefield in Employment Law. Can we jump through some of these statutes with you?
Let's go ahead, John.
Let's do it. So most of these are in the past couple of years. Colorado's Healthy Families and Workplaces Act. What's that?
This is probably the one that's going to get people in the most trouble. This act requires paid PTO, essentially, for what's called safe leave. That's for employee health related reasons, as well as for domestic violence leave. And the gist of it is for every 30 hours worked, an employee accrues 1 hour of paid leave. And this applies to all employees as well. This is part-time, full-time, temporary. It doesn't matter. As soon as they come in the door and start working for you, they start accruing this time.
Now, you said we need to comply or we get in trouble. Now, all of these, an employee could call, is it the Colorado Department of Labor?
An employee could call the Colorado Department of Labor. They can call a plaintiff's attorney who.
Or even scarier.
Yeah, an even scarier concept right there. So yeah, there are people out there, there's plaintiff's attorneys who they specialize in this.
And so we're going to run through, there's a dozen or so of these, all of these have the same trigger. An employee who is disgruntled for any reason could call and complain about any of these to a plaintiff's lawyer or the Colorado Department of Labor.
The problem is not just this reason, but if they call and a plaintiff's employment lawyer is worth their salt, is going to walk through all the policies and procedures that a potential employer and see how many violations across the board he can find for not just this, but for anything else.
Well, let's go to the next one. Colorado's Protected Health, Safety, Expression, and Whistleblowing Law. And it's called FEW, and I can barely get through the name of it. What is it?
FEW came out of COVID, and it was one of these pandemic laws that people felt were so great that they went and expanded upon it and made it full-time, if you want to call it that, across the board for employers. FEW protects employees who from retaliation and interference for a number of different reasons, mostly associated with raising complaints about workplace violations, workplace safety issues, or participating or making a claim or an investigation into essential violations of in the workforce. It started with the pandemic. I think the mask rule, the employees critiquing employers who were not following the mask rules, and it expanded from there to all types of workforce and safety violations.
Incredible. And that's here in Colorado. There's probably a federal law equivalent.
That is here in Colorado. Well, the federal law equivalent is your OSHA type, but this is specific here to Colorado.
The next one, Ban the Box, also known as Colorado's Chance to Compete Act.
This is meant to address the problems that reformed criminals, prior criminals, or people with criminal histories were having when applying for jobs. Initial applications used to require a box, and that box would say, check here if you have a criminal history, and then provide an explanation. This bans the box.
So we've banned the box. The next one, Colorado's Equal Pay for Equal Work Act.
Correct. And this law, I have to put an asterisk on this. It's changing. That's just been amended. And that'll go into an effect in a couple of months.
The amendment.
But the act essentially creates, equal pay for equal work. So there's two concepts here. One is that you can't pay the same employee differently because of some sort of characteristic, or whether they're female, whether they're a minority, those individuals can't receive less. It also goes forward and says that when you're essentially advertising job openings, you have to post not just a description of the job, but also a salary, a range salary, so that your employees know how much people are particularly getting paid for that position. And there's a number of different criteria involved with that, but that's the general gist of it.
Now, this next one, we already talked about the Colorado Healthy Families and Workplaces Act. There's a new act that imposes individual liability for employers.
Not just employers, but personal liability. So, and this is not just for the Healthy Family Workplaces Act, but also for the Colorado Wage Act. Essentially, what you were having were situations where employers felt that they can get away with not paying employment wages because they wouldn't be personally liable, especially if a business is on the verge of shutting down or going insolvent. But now that liability could also extend to managerial or executives that are involved in employee payroll. So you can find yourself personally liable and on the hook for paying not just what's owed to the employee, but any penalties or fines that are associated with that violation as well.
How about the payment of earned vacation time?
So this was a misconception that this Colorado Supreme Court corrected in June of 2021. I shouldn't say misconception, it was a gray area of whether or not an employee upon separation of employment was entitled to accrued vacation time that they've earned under a policy with their employer. And the Colorado Supreme Court came back and essentially said, yes, you have to pay that. That constitutes wages. And if you forget to, or you deliberately choose not to, then you're on the hook.
And I see now, and again, this article's linked with Adrian Castro's name. We just did a video on payment of wages, and this is not a new act. This is just a Colorado Supreme Court, not just, but it is a Colorado Supreme Court case. And we've already done a video on that, but that's still a change in the law.
Well, because of it, the Colorado Department of Labor issued a number of guidance policies out there that touch upon this.
The next one, restrict covenant agreements. It's not, is that the name of the act?
No, this is the changes that were made to the non-compete, non-solicitation statute that impacts employees. And what this does, it makes non-competes and non-solicitations harder to enforce in Colorado. They're not necessarily void, but they're pretty close to it at this point. There's only a small subset of individuals out there.
Right. And we just did a video on this, and like all of this, it's a lot cheaper to call Adrian before you do engage in anything with your employees, have them sign agreements that have non-competes, non-solicitations, non-disclosures. If you haven't changed your forms, if you haven't talked to somebody who knows what they're doing, a lawyer on it, you need to talk to Adrian about, are your policies and are your forms revised as of August 20th, 2022, right?
Correct. August 10th to 2022.
The next law is Colorado's paid family and medical leave insurance program.
Correct. And this went into effect in part January 1st of 2023. The actual paid family leave doesn't take effect until January 1st of 2024. But as of January 1st, 2023, employers are required to pay into an insurance pool, if you want to call it that. And during this period of time, they have to start formulating the policies and procedures that they're going to put in place to comply with this. There is an exception. They can go and purchase private plans, private programs. So there's a healthy market out there already where different companies are selling this service of providing these plans to help employers deal with this upcoming change.
The final one, we're going to talk about the wage theft and misclassification penalties.
Wage theft is big. It's always, and this is one of those areas that we discussed and which you had just mentioned. A 15-20-minute call can save you thousands of dollars. And what I mean by that is that they've increased the penalties associated with wage theft. And essentially, if you fail to pay an employee on time or at all, not only are you responsible for back wages in the event that you're found liable, but you're also liable for 2 times as a penalty that amount. So now you're paying 3 times to that employee. And if you acted in bad faith, that penalty provision is 3 times the back wages. So not only do you pay the back wages, then you're also paying 3 times that amount. This also includes payment of their attorney's fees as well. And because of the other change we just discussed, now you could be personally liable, or at least an HR manager or someone in the organization that's responsible for payroll. They can find themselves personally liable for this.
Well, look, Colorado has passed laws. The Supreme Court has clarified the law on certain aspects. There's been a lot going on in the last couple of years. So a quick call to Adrian, ensuring that your documents are up to date, your policies are up to date, procedures are up to date, can certainly save your company a lot of money, but even more importantly, there's personal liability with everything we just talked about. So,
Correct.
thanks for joining us today. Adrian's done a series of videos with us, some on employment law, some on just general commercial litigation. And thank you for joining us today.